Pooja ma'am, do you have a PPT to play?
Yes. Just wait.
I'll just give you the rights then. Yeah. All right. So the meeting is on record, and this I'll be sharing the file over Gmail as well. Now, irrespective of people joining in as and when, we could begin the session now that we are here, and we must respect each other's time. So it's 4:30 already, and we begin. See, the theme of the session, as I was mentioning informally a couple of minutes back, is about basic IP awareness for MSMEs in India, right? So now when we talk of MSMEs, these are not aspiring MSMEs, but registered MSMEs. So micro, small, and medium-sized enterprises in India, and operating maybe in different domain spaces due to their uh, sheer profile. So they can have a unique profile in terms of product market, service market, or whoever, whatever they are catering to. The role of IPR in all of this uh, comes in varied ways, as we agree. So it is not only in the nascent stage, but also probably trying to protect their whatever little innovations, inventions, creations that we have. And these days we see it's a generation of online creators also out there who are vying for, now they are getting, infected with the ideas of, oh, we can have our memes copyrighted, oh, we can have our graphics copyrighted and all of that. So we have both of you now to shed some light on how this really affects MSMEs on the real, I would say, ground level in the country from wherever you are speaking. So Swati, you are speaking from Kerala, Pooja ji is speaking from UP, and you both coming from your own experiences. When it comes to, Swati, this is for you primarily. When it comes to newly registered MSMEs wanting to approach lawyers or agents, for that matter, for any kind of guidance in this regard, कि अच्छा हमें IPR के बारे में, कैसे आपको कुछ हमें कैसे help करेगा. So what are those first one or two things that they look for in somebody they are approaching as a service provider, which you feel, it's
Apoorva,
there in the market?
I think better than PPT, we can have this question and answer type of thing so that it can be very interesting to them.
Yeah, even I.
Yes, of course. But then PPT will add that little bit of color to it when it's getting
Students are
recorded.
not there, no? That is why I'm telling you, because students are those who have some information. So, but we can give you the lesson. We can give you the things what is important. Okay? Like, so I think we will share their experiences. I will share the important points. What is to be important point that they have to take care by if it is a startup or if it's an MSME company.
Yes, sure, ma'am. Please go ahead.
Yeah. Yeah. So the first thing actually I feel that the MSMEs are looking for is that the attorney or the agent who handles their IPR, they have to be approachable and they have to be like present in all the doubts and all throughout the process. Like they don't want someone who is just doing their application, like starting their application process and then they're just leaving them there. That doesn't work for them. So what they want is someone who can guide them through the entire process, and the same time who is present with them through the process and who is interactive with them and lets them know where their IP process is standing. And the second thing most MSMEs are concerned about is the cost. Because first thing, nascent MSMEs, which are in their initial stages, they are not very much open to make heavy investments in IPR right in the beginning. First thing being that their own financial capacity could be quite capped or could be quite limited. So the two things that they are looking for is constant presence, and at the same time they are looking for some kind of financial benefit. like, like some cost efficiency in terms of IPR, what I feel, like in general.
Right. So the first important thing takeaway which I felt was hand holding that you talked of, so that there is, clarity in every stage and the person is there like a mentor. And secondly, of course, the cost effectiveness, right? Cost effectiveness and the fact that they understand, okay, what the other person is, where they are coming from. They won't be able to invest too much.
Yeah, and I feel that mostly MSME, like an MSME holder or a registered MSME business person, they are not aware that MSME, by having an MSME certificate can actually help them claim a rebate in all their IPR application, may it be trademark or may it be patent. There is about 50 to 80% of rebate which the government is providing, and they are not actually aware of it, and then they end up thinking that registering an IPR can be quite an expensive process. So that itself can, like that lack of awareness itself is causing some some sort of hesitation in this industry, that or some kind of a kind of what do I call it, a negative kind of a view, that filing an IPR is going to be very hefty on their pocket.
Something of a disconnect
And
of sorts. It's frustrating the purpose.
yeah, exactly.
Right. Pooja ma'am, what is your take on this? So when registered MSMEs come to you, first thing, what do you see in them and what do they want from you? Ma'am, you mute.
Startups come to my approach me that we have an idea and we want to file a patent, but the important issue is that financial problem. Okay, we don't have a money. If we go with a simple patent attorney, they charge very high amount. Like for patent filing, they charge 1 lakh or 50,000. So now, what is the benefit if we have a MSME registered firm or we have a startup certificate? Now, so there are two things. One, if you are a startup certificate, you are a startup company and you have a DPIT certificate, you don't have to worry about the charges because the government is giving a very good option for you that if you have a DPIT certificate, you only have to give the government fees. Like you don't have to give any professional charges to the IP facilitator, which was appointed by the government. Like I am also working as an IP facilitator for the startups and MSMEs. Where when we are talking about the startups, you have to give only 1,600 rupees for filing an application. That's it. Now, the total amount for the startup, if they have a DPIT certificate, you have to give 1,600 for filing patent, then 2,500 for early publication, sorry, 8,000 for examination. So after that, like 1,600, 2,500, 4,100 and 8,000 expedite one. Like in only अगर मैं करूँ तो 12,000, 15,000 में you get the grant of patent application. तो पेटेंट फाइलिंग से लेके ग्रांट तक आपको सिर्फ इतने ही पैसे देने हैं. If I am talking about the DPIT startup certificate. Now the other hand, which we are talking about MSME. So MSME, medium, small enterprises, they also, the government is also giving a benefit to them. Like the important benefit is giving, like suppose if you have hired some attorney for filing a patent application and the amount they have charged for filing a patent application, so you have an option from MSME that you get the reimbursement of your amount. Okay. So like when you have a grant of your application, when your patent has been granted, your trademark has been granted, your copyright has been granted, your design has been granted, you go to the MSME reimbursement scheme and you put all your invoices there and you get 1 lakh rupees for your grant. For example, if your attorney has charged 20,000, 30,000 for filing till grant, so all 30,000 will be reimbursed from the MSME. So this is the most important benefit that MSME is getting. Same startup also getting, like in startup category, we are not charging any professional fees, but the government is giving 15,000 to us for helping the startups in filing the patent application. So again, the reimbursement of for the patent attorneys is given by the government for the filing till grant. Like 15,000 we have to give, we will take from the patent office at the time of filing, and rest 15,000 we will take at the time of grant. So it means total 25 to 30,000 is given from the government to us to filing and take care of all the startup IPR filing. And same way, when we are talking about MSME, So if you have taken like some attorney help you in filing your trademark, now in that case government is again giving 10,000, I think, for this MSME. Government is giving 10,000 for trademark and 1 lakh for patent filing. And if it is a PCD application, like if you have filed a patent outside country, okay, and the expenses that you have incurred on that patent application, so up to 5 lakh amount you are taking back from the MSME. So this is a benefit that you are taking care from the MSME in the startup when you are filing the patent application in this both categories.
All right. Anything else at this preliminary stage which any of both of you would like to add, Swati or Pooja ji, when it comes to specific IP fields, like for example, let's say trademark, because बहुत ही common होता है एक नाम को protect करना. It's the first thing which comes to our mind. So trademark में it's not about like I'm not asking about the money involved or anything, पर जो इसकी फायदे होते हैं, एक प्रॉफिट्स होती हैं एक एंटरप्रेन्योर को, वो हाउ फार रीचिंग इज इट? बिकॉज स्टार्टिंग में हमें पता है उसका क्या बेनिफिट्स है, बट टू टेल दैट, टू कन्वे दैट टू एन एंटरप्रेन्योर, ताकि उसे उस पर भरोसा हो कि हाँ ये चीज मैं करूंगा गवर्नमेंट से तो मुझे आगे फायदा है इस चीज में. सो व्हाट एग्जैक्टली आर द कंटूर्स ऑफ दैट बेनिफिट? एंड लेट्स suppose something happens, something unfortunate in terms of running into a litigation. So what are the probabilities or the chances that an entrepreneur who is a registered MSME?
Few points I will cover. Rest Swati will cover because she take care already the trademark and the copyright work. Like the benefit of any IP. When I'm talking about any IP, whether it is not only trademark, it can be a copyright, it can be a patent, or it can be any other intellectual property, right? So intellectual property basically is an idea. Okay, any idea comes in your mind, whether you have to start your own startup or whether you have to run with your any idea, or whether you have to franchise your idea to any company. Now, so it's related. First of all, you have to find out when you are starting your own company, the first important trademark or first important IP is to file a trademark. So now it gives exclusive legal rights over your intellectual property, and this exclusive right over the trademark entitles the owner to prevent its misuse against the potential infringer. Second, to build the goodwill and the trust. That is why trademark is important. Third, when you are becoming a brand. Okay, so in future, if any competitor comes and easily copy your trademark, so what is the benefit of trademark? You cannot sue that person because you are also not file your trademark. So to sue that second party or third party, the first important point that you have a legal right in your hand. So how you can get the legal right? By filing the trademark. So by filing the trademark or by filing the patent, you are now secured that if somebody copy your idea, if somebody copy your invention, now you immediately send a legal notice to that person that you cannot do so because this is my intellectual property. Okay, so this is an important benefit when we are talking about trademark, IP, copyright, and any other intellectual property. It gives you the symbol for quality. It differentiates the product from each other. That is why we people file a trademark. It builds a goodwill and trust in the consumer. Okay, and it gives you the infringement protection. That is why we file a trademark. Okay, and when it comes to the litigation, so again, suppose if you are using your trademark of any other company without taking the permission, so ultimately you have to pay the damages for that. So these are the disadvantages of the trademark. If you have not filed your trademark and some type of litigation comes across again in your business, then how can you stop other person? Okay, so intellectual property is, it's a total illegal assets that you have to protect the day one you start your business. So I suggest my clients and startups and students and universities also, because I am working with a lot of universities as an IP advisor, as an IP consultant. I am working with a lot of startups and MSME, that if you have an idea, you please don't disclose with any other person. Once you disclose your idea and it comes in public domain, so there is no novelty in your invention. So the first important rule of patent is that if you file a patent, you don't have to disclose anywhere. Okay, so the thumb rule that you have to take care, you don't have to disclose your idea in any exhibition, any conference, any hackathon event. So if you are doing so, and somebody copies your idea and working on the same example, working on the same, prototype, so you cannot stop that person. Again, the patent office has again a benefit to them. Like if you disclose your idea in any conference, then you have one window open to you that within 1 year, from that exhibition, from that conference, or from disclosing the abstract paper in any conference, you have a period that you can file your patent application. That time your patent will not be anticipated. But if the 1 year period is over, then you don't have a right to file your patent application. It means if it is already in public domain 2 years back, then you lose the right. Okay.
Right.
So Swati ji will have more views on this.
Thank you, ma'am. Swati, there was this little point which was bothering me a minute back when I was listening to Pooja ji. When we talk of filing notices to those people who, mess with others' registered IP rights. Now, let's say something very common comes to our minds as lawyers, filing a cease and desist notice. Now let's say you send that cease and desist notice to someone who's apparently messing up with someone's IP, right? What are the chances and probabilities that so much IP awareness is there in today's startup landscape that just after receiving that notice, the wrongdoer will back off? Or is
Well,
it like 90% times is it taken to court?
in like general scenario, 90% of the time, there is a high possibility that the person to whom a legal notice is extended, they back off from using the trademark altogether.
Right.
Because one thing is, everyone around us know that getting into litigation is going to be quite a time consuming as well as a very effortful process for both the parties, to be honest, but especially for the infringer, because like generally people do file, for example, in filing of trademarks, for example, there are quite a lot of people who purposefully copy a well-known trademark and try and file an application in similar classes and try to uh, uh, like induct similar products in market. Just for example, Bisleri. So Bisleri is a very well-known company in the bottled water industry. So Bisleri ke hi, there are like quite a lot of first copy water drink. There is Bilseri and there is Bisli and something which looks exactly similar to Bisleri,
Right.
but in one look you can't make out that it's are the same things. So especially in these kind of scenarios, one legal notice is enough for a person to stop completely using that product. And in certain cases, especially in product industry, where notices may not have worked, what the general practice over here is to like stock appropriation. Like they do stock appropriation. They, like a raid in the industry is like such kind of factory is conducted, like a police complaint is filed, and then the police conducts a raid along with a health officer or any officer in concern, and the entire stock is recalled, and along with that, whatever profits have been appropriated, those profits are adjusted and paid back to the original trademark holder. But in a normal scenario, one legal notice is mostly sufficient for a person to stop using the trademark, because a trademark or any IP for that matter, because now there is a certain amount of awareness among people, like, okay, like what, uh, you know, this IP is actually something that cannot be copied from another person. So this not just in FMCG, this happens in quite a lot of industries. That this happens in travel and tourism industry also, mostly in industries which have a high amount of competition. Like people want to stay relevant. So
Right.
usually that's the place where this happens. But even then, they're not like uh, okay enough to carry on the litigation, because at some point maybe even they are aware that they have infringed that IP.
Also, what
So
about so building from here, Swati? What about industries who are let's say who are in the e-coaching space,
mhm,
in the online education space. Now they, yeah, as we are aware, they come up with various programs, courses, academic content heavy material. How feasible is it for them to have their dynamically being updated material to be copyrighted frequently, or is it even like advisable to go for the same?
well, when where copyright is um, concerned, copyright, it's good if it is registered. It's very a valuable IP. But then again, for every material that is original, there is an inherent copyright already existing, because copyright is not only a legal right, it's also a natural right. Right. So there is an inherent copyright lying. So even if an edtech industry, they have original materials and they do not have a copyright registration, they can still approach the court if someone has infringed their natural right, so long as they can prove that their work has come, like has originated first, and that their work is original. So as long as they are able to prove that, they can very easily claim their seek remedy for infringement, even though they do not have a copyright registration.
Because in copyright it is not mandatory, na?
Yeah, it's not
Yes.
mandatory because it's a natural right, because
Yes.
it's
Yes.
already existing when their
Absolutely.
work is original.
And that makes it quite unique as well, because these days we see the lot of before coming into the physical space, people want to test waters as educators through YouTube or such video channels. Now any content that you're uploading on those video platforms can
Mhm.
also be lifted or copied unlawfully by somebody in the physical space, because
Mm.
Yeah,
now the mediums are changing, right? They are shifting from a video content to, let's say, hard copy content being distributed in classroom, that too in bulk. Now the copyright certificate is the only evidence that the first author will have with them,
Mhm.
right? So then what do you say about those kind of situations where the medium is changing?
Well, when it comes to YouTube and entities like YouTube, which have video streaming, like it's a video streaming platform, they have their own set of rules to regulate copyright infringement first. So when it comes to YouTube itself, they follow this thing called a DMCA, Digital Millennium Copyright Act, which is a copyright act of the US. So how generally that platform works is that if any content is posted on YouTube and it has some kind of material which could have been taken from the physical world or could have been taken from any other video for that matter, they check like if any complaint is raised. Like YouTube itself has a complaint mechanism for dealing with copyright matters. So say if any complaint is raised, first thing that is checked is that if the infringing material is extending more than 30 seconds in the video, only if that is the case, then a warning will be given to the YouTube user to remove that video.
Yes.
Uh,
Yes.
yeah,
Strike
on the
out. They do strike out, na, and they stop that video also.
three warnings they have not
Uh,
removed the video, then they strike off the video.
strike out.
I
Yes.
think when it comes to the physical world, uh,
Uh,
it should be ensured that 30% of the entire material, like the copied content should not exceed more than 30% of
yes. Yes.
the entire material that has been posted. But
Mm.
then again, it depends upon how and for what purpose the material has been copied from videos to the physical material. If it is for private purpose, there is no copyright infringement. So that matters. If the copyright infringement will only comprise when the video content has been used for physical purposes and only meant for commercial purpose, not for any other thing. Like it doesn't matter. Like if
Of
it is
course,
used
that
for
does matter. Yes.
or if it is used for private use, or if it is
Because
excuse
then it
me.
will be hit by fair use as well.
Like Apoorva, the plagiarism, when we are talking about the paper also, na, or any other content, the patent office says the plagiarism should be less than 15%. Okay.
Yes. Swati, I've just muted you so that I could hear Pooja ma'am better. Yes.
So I'm saying the acceptable plagiarism percentage, na, when we are talking about any content, so it should be less than 15%
Less
or
than
below
15%.
15%.
Yes.
Yes. Okay. So because this type of similarity show little or low or no copying. But if you say that when Turnitin is a software, we will
Yes.
check the plagiarism
Yes.
for any content or any work when we are talking about any research paper. So when faculty check that research paper on for that plagiarism, if it is showing 25% or 30%, so they will not going to accept that paper for the copyright. They say, ma'am, this is already a copyrighted material that you have taken this paper. So below 15% considered to be acceptable thing. Other than it will, by default they will not accept that papers.
Right. In fact, in law, in many academic branches and universities, it's below 10%. So
Yes, yes.
that is
So
also there.
I also suggest my in PPTs when I am giving a lecture to the universities for the students, that if you are doing something, if you are taking some material from the internet, so please acknowledge or please give the references to that video or to the links that you are copying from that page, or please the abstract and the content should be written in your own language. Okay, plagiarism should be checked before filing any work related to originality, and references should be given. अगर reference नहीं दोगे, reference quote नहीं करोगे, तो कल को वो inventor, वो author आपको sue कर सकता है. So that is why अभी एक बहुत recent case आया था DU का था मेरे ख्याल से, I don't know. So एक inventor ने एक paper present किया, and जो author था जब paper present किया तो उसमें उसने जो work था उसका आधा content किसी foreign inventor का involved था उस paper के अंदर जब paper present किया. So when that foreign author come to know that this content is mine, how can they have filed a paper on their own name and they are not giving any references to that paper? In that case they have sued that person, and 2 crore rupee penalty they have incurred on this paper, and by default वो सर की डेथ हो चुकी है. जब मैं कॉलेज में गई तो उन्हीं का केस था, तो दे टोल्ड कि मैम उनको हार्ट अटैक आ गया by seeing that notice. So these are the implications I told in the university and colleges also. These are the implications because students are not aware. Okay, when they are copying something from the internet, they are not changing the graphics, they are not changing the content. They are just, when we are talking about the project reports, if they have to submit the project report, what they do, they go to the Google, they type the keyword, they download the report, and they put their name and submit to the faculty. So again, they are doing a very wrong work because it is again a copyright infringement. So I told your IP address is very important when you are cheating or when you are copying something from the internet. So when you are using the internet of university, at that time at the library or the computer lab, your login period is there. Okay, and if you have used that laptop or a system for this period of time, and you have used some content for any commercial purpose, then you are liable for this copyright infringement. And copyright, you have a criminal and civil suit, na? Then you can be imprisoned also. Imprisonment option is also only in copyright, not in patent, because in patent you have to give damages.
Right.
The invention that you have used. Okay. So that is an important point that we have to, like, now the lot of awareness sessions are created in the universities and colleges so that they are aware about this thing, that we don't have to copy something, but we have to, like, they have to give the references or they have to written in their own language.
Absolutely. Swati, anything you would like to add here? You muted. You muted, sir.
Yeah, building upon what Pooja ma'am has said, not only in colleges and research paper, these thing is very rampant in social media also these days, where content is continuously shared. What happens is that there are quite a lot of pages which share content of other people. Sometimes they do so without the prior permission of such people. It could be any kind of content for that matter. It could be some song or some dance or some original score that a person may have created. And people are not quite aware that social media ke caption may, if they mention no copyright infringement intended, it doesn't work.
Yes.
Even if it is like it acts in such a way that you just go and randomly hit a person and then they say sorry that I hit you, please forgive me. That doesn't work that way.
Doesn't work.
It equally causes hurt in the sense it like hurts the publicity that the original owner might have gotten in a good way, even when credits are not given, and they just post some content or some pictures or some
Probably
videos
the
without
moral rights are also disturbed.
Yes.
exactly
Apurva is right. The
moral
moral rights are also hampered, no? So it
so
is important.
by saying that there is no offense intended, it does not absolve them from any kind of liability. They are
Liability.
equally liable to be sued. They could be imprisoned, like Pooja ma'am said, they could be imprisoned, or any civil suit for injunction, or civil suit can be initiated against them for these kind of conduct online.
Now, talking about the financial angle of IPR in the growth journey of an MSME, how relevant or how significant does it become when let's say once small entity now grows or decides to get merged with another bigger entity, or decides to transfer certain shares, or go run in the market through a franchise or a license model. Now, what is the relevance of having your IP rights acquired at the right time for this kind of a growing entity? Whether it be any entity, product, service,
So
market, or e-space.
yeah, IPR, in my opinion, especially patent and trademarks, they help in enhancing the market value of a business. So when there is a certain kind of brand value generated for any kind of product, or such product has been monopolized by a company by obtaining patent for it. Such companies, when such companies are being merged, or they are being acquired or taken over by another entity, such brand values play, quite a big role. In terms of acquisition, people like big businesses go for those companies or those brands very high recognition in market, and having having an IP registration can actually enable them to create that kind of exclusivity in market to improve their market share. Just for a simple example, Maggie Lelo. Maggie is a very well-known trademark in India. So regardless of what kind of instant noodles that we see in the market, सबको Maggie ही बोलेंगे. You will not call it by any other name.
We have another brands also like Yeezy and other noodles.
But even in general trend, even if there is a Yippee, or even if right now there are quite a lot of, there is Nissin and some other brands like that, but even then more recognition is only like Maggie का आता है. Like people know instant noodles by Maggie. Nobody calls it an instant noodle. They all call it Maggie. So that's the power of trademark. That's how much a registered trademark can help push the brand forward.
In fact, I mean, that is the logic I feel behind the tagline of Coca-Cola for the longest time, Thanda matlab Coca-Cola. Because they have been wanting the consumers to think on those lines. कि आपको गर्मी लग रही है, ठंडा चाहिए, तो it is only Coca-Cola.
Yeah. And
having अमूल दूध पीता है इंडिया, तो by
अमूल का दूध पीता है इंडिया.
Associate करवा रहे हो consumers को.
Yes.
Right.
वो LIC जिंदगी के साथ भी, जिंदगी के बाद भी.
जिंदगी के बाद भी. Yeah, so these kind of trademark, it not only creates an identity among people, it also creates some kind of security around the brand. So when other companies are trying to acquire or take a license or franchisee of our small enterprises which are capable of becoming bigger brands, their registered trademarks come into quite a lot of play. They go for only those kind of trademarks which are registered, and at the same time they have gained some kind of what do you call it, some kind of an identity, an exclusive identity in the market, like which has a certain kind of value in customers or among customers, or there is some kind of recognition among the trade circle. Only those kind of brands are highly preferred, and registered trademark can actually enable that to happen.
Yes. And moreover, we are also like when an investor want to invest in your business also, so they first see that whether your IP is protected or not.
Yeah.
They have to spend like 50 lakh rupees on your any single product, or 1 crore rupees on your single product. And if your IP is not protected, so they don't want to invest in your product, because they think that some future, if this brand will copy by any other person, or if it is already copied from any other person, so by investing in that amount, it will come into a litigation part in future. So they don't want to go for this kind of practice. So first, the important point, they will see whether IP is protected or not. Only then they will go further. So these things are not only important for commercialization or licensing, but when we are talking about startups and investors or incubation centers, that again play a very important role.
Yeah, and right now, IPR, like having an IP registration is not only like helping domestic commercialization, it is also helping the MSMEs and startups to enhance their exports, because especially when it comes to electronics, and even for the matter, consumer wearables like clothes, bags, or shoes, etc. Whenever something is exported from India, or whenever something is imported from like from other countries, now the EXIM authority is giving a huge consideration to see whether the brand of such a product, of consumer wearable or electronics, have been registered, and they have obtained having just having an application is not sufficient. They have to get a registered trademark, and only then it will enable them to export their product, or get branded products imported to India. So there also, for international commercialization, IP registration plays a huge role these days.
Makes a lot of sense that way, because if you're not serious about your own brand or capitalizing on its know-how or whatever is going into it in terms of knowledge and efforts, then why would the customer or the possible stakeholders be concerned and serious about the same? So yes.
Yeah.
Thanks.
And up to certain extent, it also helps in infringement of trademark rights on an international level, especially only registered trademark goods are sold, exported to other countries. We can ensure that even on an international level, there is no trademark infringement, and your brand stays completely unique and exclusive, and in the names and circle of the consumers.
And on the flip side, do we see these kind of MSMEs trying to act too smart and deceptive, let's say, by trying to capture other person, unlawfully capture the other person's market through, kind of copying their IPR, or just playing it very casually when it comes to someone's registered trademark or copyright or patent as such. So do we see that kind of a trend also in the market these days?
Yeah, absolutely. Actually,
Thinking कि अरे
um,
हम तो छोटे player है, we will not be identified easily, and these are
yeah,
very, so like you talked of well-known trademarks, so there is a stash below that as well. So not all
yeah.
trademarks fall into that legitimate category of well-known trademarks, but they are nevertheless well-known in their own domestic market or space.
Yeah, there are quite a lot of businesses that have similar practices, same practices. Especially recently, there has been a case with Cadbury's chocolate. We all are aware of gems, and there was this infringing trademark of similar gems like candy called James Bond. So gems and James. So then in such cases, there are quite a lot of products wherein, people think that a particular brand is very popular in India. So even if they start something deceptively similar, only for sales limited to a certain area, it wouldn't matter. But it doesn't work that way. Uh, they have to keep in mind that any product or any service that they are about to launch, it has to be unique. That is the main crux of having an IPR right in the first place. It has to be unique. It has to be their brainchild. It cannot be a copy of somebody, else's brainchild. And all of the IPR offices, may it be copyright or trademark or design or patent, they have a very strong mechanism for uh, the suffering party to take action against such infringing party right before they obtain registration for such trademarks, like for such IPs. For example, in trademark, after a trademark application has been accepted by the trademark office, there is a time period for 4 months wherein the trademark is published and it becomes open to third parties to raise an opposition for the registration of such trademarks. So right from the grassroots level itself, the companies are given an opportunity to avoid any kind of infringement. Then again, there are quite certain cases where, due to a lack of action, some trademarks do get registered. But even then, as I took an example of gems, at the end of the case, the infringing party was um, imposed with a penalty of somewhere around 2 crores, which they had to, not 2 crores, 20 lakhs, which they had to give to the Cadbury's company, that is Mondelez India Private Limited. So such strong actions are available for party which is suffering. Right. So people have to keep in mind that their actions have consequences, so they cannot just loosely copy a trademark or loosely copy inventions and just get away with it.
Plus, these days, I mean, it's important to remember that internet has a huge role to play. So we can't really say, ki, Acha, this is A territory and that is B territory, and it's watertight compartmentalization between the two when it comes to dissemination of information regarding IPR, or playing with the consumer's mind, because that kind of advertisement is happening fluidly, right?
Yeah.
So, yes, that again is one factor. Pooja ma'am, you would like to add in here anything, any concluding comment that you would like to make, and then we could wrap up. Pooja ma'am, are you there?
I
All right. Can you hear me, ma'am? Okay, so before we wrap up, Swati, anything which you feel we could add more to it in the next part or the next series that we have on the same, or uh, we kind of escalate this into another something, similarly interesting for startups and everything.
Right. So I feel that you know आईपी का अवेयरनेस बहुत ज्यादा होना चाहिए. We should have more such seminars and campaigns to make people more aware that they have certain rights and they have certain opportunities where they can claim it and exploit it for
Right.
their own benefits and for the benefits
And
of
these,
their
these are pro
businesses.
bono initiatives where people register voluntarily and they decide to not turn up. So this is what have
So,
fate of awareness initiatives in a lot of ways, but then it's not something we can get
yeah, I
disheartened
think
with.
for that, I feel like, somewhere money is the motivating factor, wherein
It
they
is.
have paid certain amount and they'll be like, अरे बाप रे, हमने थोड़ा तो पैसा दिया है तो आना पड़ेगा
Ana
kind
padega.
of.
Yeah,
हाँ.
that's the reason. Yeah,
But we do have to conduct more such sessions because awareness is very much important.
that is
Even
true.
now, I feel like most traditional as well as new businessmen have a very business persons have a very ignorant attitude towards IP.
Right.
Uh, they just take it in a very casual manner, like क्या है हो जाएगा. But they don't realize how valuable it is until it's too late. Even in my experience, there are quite a lot of like trademark applicants and holders around me who just they who come to get registration only when they realize that there is a there could be a possible infringement, or
Right.
they do it after they realize that they have been infringed, like their rights have been infringed, and if they had such a registration they could have stopped from something like this to happen. So
Happen.
they wait after everything is done. So where they have an awareness, like they can get
This
a
can be
registration at this
prevented. Yeah.
particular point of time. They can take proper preventive measures. So then I feel like there will be some kind of movement in this IP industry. Like IP industry will boom even more.
Absolutely. So awareness is the key. And finally, I'll just one more time, I'll try my luck and ask Pooja ma'am if she's there. Ma'am, would you like to add something before we wrap up?
Yes,
Yeah.
I just want to say to the my audience that if you have any idea, if novel idea, and you want to start your own business, first important point that you have to keep in mind, okay, file a trademark, file a copyright, or file a patent for this. Unless and until when you grown up, like when your business has been grown up for a few years, and after that you become a brand, and now, if someone copy your brand, and then at that time you realize that you have to file a trademark at least before starting the business, so it is late. So, best important thing that if you are a startup, MSME, any company, any startup, so first protect your trademark, then start your venture
Business
first
first.
further. Okay. So otherwise, if you are not doing so, you come to a litigation in any time at the future, because you can't know that somebody, when your brand is popular, somebody can copy your design of your product, somebody can copy your trademark. For example, very important case of Starbucks and Sadaji books.
Yes, this is one
Remember
of my
Starbucks and
favorite
Sadaji
cases.
books? This is a very good story by Apoorva. I think she will tell you. So how this trademark affected India brand? Apoorva, I think you should go with this.
Just briefly, I would say there was this cafe having multiple commercial outlets in Delhi NCR areas, and now all across the country. And they used to, when they opened up, and they were quite proud about the fact, oh, we have 57 outlets, oh, we have this, we have that. And that was a time also when they were slowly unable to understand how they scaled so fast. Probably they had a franchise model or whatever it was, maybe it was hugely capital intensive. But they went into from, one outlet to a 50 plus outlet in no time, with the consumers not even, too aware of their brand. However, the target audience of that cafe, Sardar Baksh, was similar to what kind of people walk into a Starbucks, right? And
Starbucks.
things were made worse by the fact that their logo appeared very similar in terms of a bottle green Sardarji sketched somewhere, looking very familiar and similar to that queen which is there in that Starbucks logo, with
Starbucks logo.
same bottle green, yes, background. So that was there. Then the phonetic similarity was there. Of course, the deception element was very active in the consumer's mind because that could have been potent. They were selling this almost same kind of deliverables, whether it be the snacks associated with coffee or different varieties of coffee and cappuccino and all of that. So that made me think and question the owner one of the days, and I just asked him that, don't you think you have the risk of, you bear the risk of being threatened by Starbucks in a very legitimate manner that
Yeah.
तुम इनके trademark के साथ छेड़खानी कर रहे हो? They did not take me seriously that time, and in a few weeks they got sued. And the matter, it's there if you Google it, you'll find it. With the Delhi High Court gave amazing judgment on it. So they kind of reconciled in the way that Sardar Baksh became Sardar G Baksh, so then they didn't have to pay that kind of damages or anything to Starbucks, or they could have risked losing out on a chunk of their commerce. Also,
Yeah.
they changed the logo altogether. So they made it black with a prominent Sardarji there. So now that element of
Now there is
similarity
a
got reduced.
visual
Yes.
dissimilarity appears there.
Yes. So to think कि अरे nobody will notice, ऐसा कुछ नहीं है. ऐसे आजकल बहुत with chat GPT round the corner, बहुत AI supported tools भी हैं जिससे आप free domain में ही पता कर सकते हो कि कौन आपके IP के साथ खिलवाड़ कर रहा है, and more so with well-known trademark. IP infringements round the corner, unless they are a thela or some street food joint which is not making that kind of money. So that is different. But if you're doing something in a wholesale commercial manner, then you are at risk out
Then you have to be very careful as to
there.
what trademark you are choosing to have for yourself.
Absolutely, yeah. And so is the case even with patents, like Pooja ma'am keeps on saying about, don't take it lightly. Even if you don't have awareness yourself, don't try to do some kind of, silly stuff with others' patents, because that will
Yeah,
lead you
I
to a
think
suit.
one should start the practice of conducting a patent search
Yes,
before filing a patent application. That like how trademark searches are conducted.
absolutely.
It is very important that you search if a similar patent has been filed or similar trademark has been filed. Only after that, if you pursue going ahead with it, then it will be a better thing, to avoid infringement and to avoid legal complications in the future. The same thing goes with domain name also. Whenever you're selecting a name for your business, for that matter, you have to make sure to find first that your business name has not been registered as a domain name in the beginning, to
Right.
avoid any kind of conflict, or at least make an attempt to like purchase that particular domain name so that you can avoid conflicts in the future. So to make, you have to create a unique identity or have a unique invention. Make sure that is unique and it stays unique.
Absolutely. These days, GoDaddy is running this wonderful campaign of, when you are buying a .com, also buy a .in or a .in, so that you have
And
both.
I would add one more point here, like beware from the people who says we will file trademark only for 500 or only at a price of 400.
Yes,
Okay,
absolutely.
People are going with that companies because of a very less cost, but they don't aware when it comes to the objection, opposition, it will again you have to pay a hard money to the attorney.
Yeah.
So before
Yeah.
doing a
Even
mistake to go with that 500 rupees or 1000 rupees, don't do that mistakes. Better at the starting point, at the level of start of your business, when you filing a trademark or patent or copyright, you check your
and
trademark. You check your trademark with your patent attorney, okay, whether the trademark is already existing or not. If it is already existing with particular class, you first at the time of filing you change your trademark. Because now like सब एक छोटा बेबी होता है ना, जैसे छोटे बेबी को हम ABCD सिखाते हैं, तो जैसे आप उसको सिखाओगे it will nurture like that. Okay, the phonic sound he catches the same phonic sound he repeats in the future. सो द ट्रेडमार्क अगेन बिजनेस शुरू किया है, ट्रेडमार्क रजिस्टर करना है, तो अगर बड़ा इजी है, कोई भी आपको बोल सकता है अरे मैम वो लोग तो सिर्फ 500 रुपए ले रहे हैं ट्रेडमार्क के, आप इतना क्यों चार्ज कर रहे हो? सो द पीपल द हाईली प्रोफेशनल एक्सपीरियंस चार्ज बिकॉज दे नो what is the outcome of the trademark. If it is already existing, so you have to like go in the litigation matter by that competitor. So best, please don't go to the Google to find out that we have filing this trademark. Best you can find the authorized practitioners who are having experience in their filings. Only then you can take the service from them.
Great point, ma'am, because ये बहुत rampant है आजकल market में for all kind of services.
Yes.
yeah, and
इतना चार्ज कर रहे हैं, आप इतना क्यों कर रहे हो? These kind of questions by customers and clients have become very awkward for professionals to
Yes,
answer.
and better
yeah,
if you think कि अगर ये कोई इतना charge कर रहा है, you have a Google also ना, you can find the name of that attorney on the Google, that what is the experience she have, and if she have of 20 year of experience, another person who is have just started their business having a 1 year experience, so how can you expect that that person take only 500 rupees for filing your trademark?
Absolutely.
Okay, so the quality of the trademark is again like that. So it matters that whatever the agent or attorney you have selected for your filing IP. So please have a look on their profile also, so that you can get a very good service at the time of filing till grant.
Right.
yeah.
Do we close at
There
this?
is another adding to.
Yes, Swati,
Yeah, I
please.
just have to say something more. Like adding to what Pooja ma'am had said, there is also a trend going on with these entities which have, which are offering trademark applications for 500 rupees or 600 rupees for that matter, that any kind of trademark can be registered. They take up any application because for them, like service to people is not their agenda. Their agenda is to make profits over here. And they have quite a lot of investorial backing also. So it's very justified for them. And they create a false sense of awareness among people that any kind of trademark can be registered. But
Yes,
that
yes.
is not the case.
That is not true also.
People
Yes.
must be made aware that there are a certain kind of trademarks that cannot be registered. For example, a trademark with the name of a country cannot be registered.
Right.
Generic trademarks cannot be registered, or existing trademark which is deceptively similar to an existing trademark cannot be registered. So that kind of awareness, like an online entity making a very cheap trademark application cannot provide.
Right.
An applicant. So they have to be very careful when they are approaching these kind of entities, and as much as possible, like maybe avoid going to such entities, because that's only going to end up in an objection, refusal, and after that it will just make them, it will add on to their cost burden, where they have to make a trademark application over and over.
Right.
Like a repetition of process. So that's not helping anybody over here. That also is something that they have to keep in mind, by approaching these kind of people. Like if they know what they are doing, and a proper search is conducted before a trademark application is filed.
Same in the case of patents also, na? Same in the case of patent also. Like for example, if any invention which is related to method for agriculture, or if it is a method for surgery, or if it is method for medical. If any practitioner come to us and they say, "Ma'am, we have another method for removing cataract from the eye," so I suggest that it is not patentable under section 3. It is written over there. Okay. But sometimes if it is an inventor who is saying, "I have a lot of experience in IP, I can file a patent for this." So what happens in the from the patent office angle, they will discard your application. They will not refuse your application because you have filed a patent which is not allowed in the patent office. Same for atomic energy, same for secrecy directions. So like atomic energy is not patentable. Method of agriculture is not patentable. Okay. So any copyright work is not patentable. So there are again a certain important points that we have when we are discussing with the inventor point of view. Okay, so we suggest, sir, this is not possible, but you have to make a device, then it is patentable. So this is only the important factor. That is why this whole webinar is very important, not only for MSME but we are giving a lesson to the audience that if they are approaching some patent attorneys or patent agents or any trademark agents and trademark attorney in future for filing their trademark, so please be aware about the important points with the company, the website, the IP experience, or you can go to the LinkedIn also to find out the experience of that person. So after having all much of experience, then you can give your work to them so that you have a trust with them. That she, like me and Swati ma'am or any other person like Apoorva, that they have holding that much of experience. Okay, so that experience always matter. ठीक है, तो एक्सपीरियंस मैटर करता है. एक फ्रेशर के साथ अगर आप कंपेयर करते हैं कि एक फ्रेशर जिसने आज अगर एक पेटेंट एजेंट बना है, पेटेंट अटॉर्नी बना है, I might be that person has not very good experience compared to the highly experienced person who is running from the last 20 or 30 years.
Right.
Okay. तो बी वेयर फ्रॉम दैट थिंग्स कि कोई किसी ने आपका 500 रुपए में ट्रेडमार्क फाइल कर दिया, 1000 रुपए में पेटेंट फाइल कर दिया. अगेन यू हैव टू क्राई फॉर दैट बिकॉज व्हेन इट कम टू द पेटेंट ऑफिस दे विल ऑब्जेक्ट योर ट्रेडमार्क, दे विल ऑब्जेक्ट योर पेटेंट दैट यू हैव फाइल्ड व्हिच इज नॉट अलाउड इन द पेटेंट ऑफिस. अगेन व्हाट हैपेंड, your government fees which is 4500 for filing a trademark is ruined. And for patent also, like 1600 if you have given to someone to file your patent, it will go into waste. Okay.
Right.
So
Thank
at
you.
last, we all will give conclusion that if you have a intellectual property, that any idea that you want to protect, any business you want to start, or any designs you have in your mind for your product, so better take a help from patent attorney. Don't go for the Google, and find out the good people or good practitioners to file your trademark or patents and copyrights. That's it.
Thank you, Pooja ma'am. Thank you, Swati. It was lovely to have this kind of an intimate discussion with just three of us. And I hope this reaches out. We put it up on our channel on logistics for people to see, and it reaches out to many and benefits them. Just
Thank you. Thank you, Pooja. Thank you, Swati.